complaint and about the incidents that took place. Police registered the case and commenced the investigation and were able to arrest the accused persons on 5/9/2013. Full stop. Next para. Based on the voluntary information given by the accused when they were in custody, investigation officer was able to seize 20 bags of paddy which were found missing from the cattle shed of the complainant under seizure measure exhibit P2. First, next para. Samples were drawn in the presence of measure witnesses from each of the bag and they were retained for the purpose of investigation and trial, and the remaining paddy was produced before the court, and the learned trial magistrate handed over the interim custody, taking note of the fact that the paddy is a fast decaying substance. First, next para. Thereafterwards, detailed investigation has been made and charge sheet came to be filed. First, prosecution witnesses except PW7 have supported the case of the prosecution in toto. First, next para. Mere PW7 turning the hostile to the case of the prosecution, as rightly contended by the learned HCGP, did not cause any serious dent to the case of the prosecution in disbelieving the version of the prosecution. First, recovery of the stolen article is a important ingredient while establishing the offence under section 380 IPC. First, the same has been rightly appreciated by the learned trial magistrate, and in the absence of any previous enmity or animosity nurtured by the complainant or the police so as to falsely implicate the accused persons in the case, learned trial magistrate was justified in recording an order of conviction against the accused persons. First, accused thereafterwards preferred an appeal before the district court, Davangere. Next para. Learned judge in the first appellate court, after securing the records, heard the arguments in detail in the light of the grounds raised in the appeal memorandum, and on reappreciation of the material evidence on record, not only confirmed the order of conviction but also the sentence passed by the trial magistrate by supplying the cogent and convincing reasons. First, next para. This court in this revision, cannot revisit into the factual aspect unless they are patently defective. First, the material on record would be sufficient enough to maintain the order of conviction against the accused persons. First, therefore, having regard to the scope of the revisional jurisdiction, this court is of the considered opinion that the material on record is sufficient enough to maintain the conviction which has been rightly appreciated by the courts. First, accordingly, points number 1 and 2 are answered in the affirmative and negative respectively. Next para. Regarding point number 3, that counsel for the revision petitioner contended that sentence of 1 year for the offence under section 380 IPC is working harsh so far as the accused persons are concerned, and sentence of 6 months for the offence under section 511 IPC is again on the excessive side so far as the accused are concerned. First, it is the submission of the learned HCGP that one more case on the similar charges are filed against the accused persons. First, however, neither the revision petitioner nor the HCGP is in a position to place on record what is the result of such criminal proceedings. Another criminal proceedings that was launched against the accused persons. First, next para. Taking note of the fact that accused were in custody for a period of 1 month during the investigation period, this court is of the considered opinion that enhancing the fine in a sum of ₹15,000 each, apart from the fine already imposed by the trial magistrate in a sum of ₹1,500 for the offence under section 380 and 511 IPC, and ordering the period of ordering the custody period as period of imprisonment would meet the ends of justice, taking note of the financial conditions of the accused, and there is no further complaint thereafter against the accused persons. First, Accordingly, following point number 3 is answered and following order is passed. Criminal revision petition allowed in part 1. 2. While maintaining the conviction of the accused for the offence under section 380 and 511 IPC, accused the custody period already undergone by accused number 1 and 3, who are the revision petitioners for the offence punishable under section 380 and 511 IPC, is treated as period of imprisonment. First, accused persons are directed to pay fine of rupees 15,000 in addition to sum of rupees 1,500 ordered by the trial magistrate on or before 30th June 2024. First, in the event of the accused revision petitioner failing to make the payment of fine amount on or before 30th June 2024, the order of sentence passed by the trial magistrate stands automatically restored. First, office is directed to return the trial court records with copy of this order forthwith. ನಿಮ್ ಕೆಲಸ ನೀವು ಮಾಡಿದ್ರೆ ನನ್ನ ಕೆಲಸ ನಾ ಮಾಡಿದ್ದೀನಿ. ಕಳ್ಳಂಗ್ ಕಟ್ಟಕ್ಕೆ ಕೇಳ್ಬಿಡಿ, ಮುಗಿಯುತ್ತೆ. Yes, sir. Sumana? ಎಲ್ಲಿ ನಮ್ಮ ಬನ್ನಿ. What happened? You issued fresh order?
No, my lord, there is no decision with regard to that. Therefore, my lord may consider the revisions, my lord, on their merits and pass an order, my lord.
Why they did not take any action?
Then a meeting agide, my lord, but my instruction is that there was no decision so far as this issue is concerned.
No decision in the, are they not giving any sanction order now, fresh sanction order?
In respect of these cases, Lord, the stand of the Lord organization is that the appointing authority who's
Did you communicate that to the Lokayukta? You see, there is a responsibility cast on you.
Yes.
You could say that the earlier sanction order is valid and we don't give any further sanction order. That you should communicate. Did you communicate that?
Not yet, Lord. Not yet. Because these petitions are pending, Lord, on that issue.
As regarding to CRRP 670, I am appearing for response number 2. I am submitting before my lordship the inquiry report as well as the recommendation. In both I was exonerated. In view of this, whether there be a sanction?
No, that's a different issue. We are not on that. Why are you complicating the
Because
issue?
they are party.
No, don't complicate any issue, Mr. Joshi. That is a matter to be looked into later. We are on the question of the order being there, that the sanction order is invalid.
Yes.
That's all we are on the question. We are not on any other issue. Now the question is, that has to be questioned by the Lokayukta.
Yes, which they are not done.
Wait, sir. Are you trying to dictate the court or will you
No, I
hear
am
the court?
assisting the court.
You are not assisting, you are intervening in the matter.
Sorry, sir.
Lokayukta is the aggrieved person if the sanction order is invalid, not the sanctioning authority. We are on that issue. I have requested the other side to find out how can a sanctioning authority file a revision when there is no order at all against the sanctioning authority. We are on that issue, maintainability. Your friend says, in similar circumstances, this court, the coordinate benches of this court has taken a view that the sanction is valid. That's one thing if they file a revision. If they don't file a revision, whether a sanctioning authority can come up that, my order is valid, therefore the court has held it is invalid, therefore I am aggrieved. What is their role? This is where you have to convince me.
Yes, ma'am.
Please convince.
Lord, so far as the power of the court is concerned, my lord, I have made a compilation, my lord, with regard to
Please
the
pass
scope
it on.
of
Please pass it on. Are you also ready on this questions to address.
We have to go through the compilations. And I will also, will be able to answer.
What about you, Mr. Arbati? You want to say that revision by a sanctioning authority is maintainable? You have any authority?
But the coordinate bench judgment not where we have been transposed and
No question of transposition in a criminal case, sir. What are you?
there is no.
Not,
part-
Is there any provision under the CRPC for this transposition and all?
Not, we had invoked, my lord, filed an application under 482, my lord.
Sir,
seeking
all these things
transposition.
are being done in utter disregard to the scheme of CRPC. We are following the CPC. See, these are all not
My-
permissible. Please understand. A scheme in CRPC is a distinct scheme. It is meant to see that in a particular way the procedure is to be conducted. Except for the adversarial system that we are following, as against the inquisitorial system elsewhere in the globe. No other civil proceedings, no other provisions of the civil in nature could be imported to the criminal procedure code. Unfortunately, I'm sorry to say this, unfortunately, we are following. We had the example of Order 5 Rule 20 being filed in a criminal case. Order 5 Rule 20 being filed in a criminal case and paper publication was ordered. Thousands of convictions took place in 138 and in one shot, division bench has to say all those are invalid and then sent it back. We have these examples. And the magistrate has got the audacity to tell me when I was in practice, you don't know the law. See, the problem when the subsequent order came, he has to eat his own words. See, the problem is not that.
So,
You are all, we are all here to see that, we advance the justice.
yeah, so
That's the
far,
point.
so far as.
So therefore, I am requesting you, one aspect. See, transpose, all these things is a different issue.
That was as a, my lord, aside.
Scheme does not envisage a third party to challenge an order.